Hello, I'm Catrin Mitchell and this is the Mitchell Law Tea Break. Today I'm joined by my colleague Catrin Jennett.
Good morning, Catrin.
Good morning. So for this tea break we're digging deep and talking about investigations.
Absolutely. Some areas of the HR practitioner's job involves getting to the bottom of things or looking into what really has gone on in an employment situation.
Yeah, and frequently clients come to us asking for guidance on how to manage a disciplinary investigation or a disciplinary matter, and in those cases it's usually obvious that the investigation of the complaint or the disciplinary allegation is important, but there can be other situations where an investigation might be necessary. So for example, where an employee is underperforming or suffering from stress, or where there's been a customer complaint.
So why is a formal investigation necessary then?
Well, there can be several reasons. The first is obviously it's a principle of natural justice. The cornerstone is that any person is entitled to a fair hearing, and the purpose of an investigation is to discover all the relevant facts and information in a fair, reasonable and objective manner. And in the employment arena, obviously the repercussions are potentially for a person's livelihood, and this is one of the reasons why a thorough investigation or the absence of one can drastically affect tribunal proceedings. So if the employee is dismissed following a disciplinary and claims unfair dismissal in the employment tribunal, the tribunal will closely examine whether or not the employer followed a fair procedure. And a reasonable investigation is a fundamental aspect of a fair procedure. Similarly, if a manager suspects that an employee is suffering from serious illness caused by undue stress, but fails to investigate this concern and do something about it, it could lead to a personal injury claim, which could be quite expensive.
But on the broader level, Catrin, confidence that your employer will investigate and take seriously any employment issue will help create and maintain a very positive working atmosphere. Grievances or disciplinary issues which are properly investigated promote trust. So, core principles when conducting an investigation: fair and reasonable manner.
Indeed. Firstly, the employer should decide who should carry out the investigation.
And who should that be?
Well, it's always worth checking the appropriate internal procedures, such as the disciplinary procedure, as this might stipulate who should conduct the investigation. And if not, there are some basic rules. For instance, the person carrying out the investigation shouldn't chair the disciplinary hearing. A witness to the allegations shouldn't carry out the investigation. In smaller organisations, it might not always be possible to separate roles so easily, and sometimes, but not always, using an external party can be helpful.
So the first job of the investigating officer is to clarify the issues.
Yep.
It's also good practice to inform the employee, who's the subject of the investigation, that it will be taking place, provide them with a copy of the relevant internal procedure, and give an indication of timescales and also what the next steps are going to be. The investigation should be conducted within a reasonable time frame. This is fair and reasonable and helps ensure the witness's recollections remain fresh and accurate, and to obtain useful documentation that might otherwise be destroyed.
Yes, and it helps to remember that an investigating officer's prime aim is to gather evidence and establish the facts, which might mean gathering evidence which is apparently contradictory. The investigator's job is to pull everything together, not to decide whether the employee is guilty, for instance. The investigator should take care not to be swayed by their own opinion or views of any witnesses, and not prejudge the outcome of the investigation by assuming guilt or innocence.
Presumably, all of the investigation is confidential?
Yeah, that's absolutely right. And the principle of confidentiality is going to apply to the investigating officer, the employee who prompted the investigation, and all the witnesses. And the investigating officer shouldn't discuss the investigation with other employees or with third parties. So sometimes a witness might ask for secrecy before giving a statement, which is problematic and generally not advisable unless they have a reasonable fear of an actual reprisal. So it's always natural to feel uncomfortable about giving evidence against a colleague. But again, going back to one of the principles of natural justice, someone who's accused is generally entitled to hear what they're accused of and by whom. So sometimes if there's a risk to witnesses or evidence, suspending the employee for a short period pending the outcome of the investigation can be a sensible step. It's always sensible to take legal advice before doing that though.
So when could that be appropriate?
Well, if relationships have broken down, where there are grounds to believe that the employee might deliberately cause damage to the employer's computer network, for example, if they remained in the workplace, or where the employee's continued presence at work might prejudice the investigation in some way, for example, where there's a risk that they might intimidate witnesses. And any suspension from work pending the result of an investigation should always usually be with full pay and benefits, and take some advice if in doubt. And do make sure that the employee who is suspended is interviewed to establish core facts. You may also have to review other witnesses following that evidence. And it can make sense to re-interview if you've gathered contradictory evidence and go back to make sure you're clear if necessary. Before any witnesses, including the employee, are interviewed, the investigating officer should prepare a list of the relevant questions, point out and question any discrepancies, not be afraid to challenge what the employee is saying, and make sure the whole story is uncovered.
So can the employee be accompanied at any meeting?
Unlike a formal disciplinary hearing, generally employees don't have the right to be accompanied at investigatory meetings. So some employers take a view that it can be helpful to agree to a companion, but there's no statutory right. And after the interview, the investigating officer should prepare a witness statement based on the information that the witness gave, and as far as possible, it should be in the witness's own words. The manager should then send a copy of the statement to the witness for the witness to amend or otherwise date, sign and return.
So that brings us to the rest of the evidence.
It does.
You may also need to consider a range of other evidence, depending on the reason for the investigation. Absence records, clocking on, clocking off records, written appraisals, training records, letters of complaints. If you need to rely on electronic records such as CCTV or email and web browser history or phone logs, I think you have to check your internal documents first. That's the first protocol, and make sure you're satisfied that you've thought through everything regarding data protection and surveillance issues, including whether the employees are aware of for the reasons that they're being monitored.
So what if an employee refuses to provide documentation?
The investigating officer can't compel an employee to disclose personal documents, but work documents belong to the employer. If the employee refuses to disclose evidence at the centre of the investigation, the manager should point out in writing that a refusal to cooperate will limit the depth of the investigation. They'll have to take a decision on how to proceed on the evidence available, and that the employee's failure to assist with the investigation could be viewed negatively when determining the outcome. If it's another employee obstructing an investigation, well, that might be a disciplinary matter in itself, as in extreme cases could be a refusal to give a statement.
So the investigating officer has gathered all the information. Now what?
Well, produce a report in most cases, which is much easier said than done.
So some top tips for a good report. My tip is to think about the structure first. Have an introduction to set the scene. Explain your methodology, set out your findings, and then summarise them at the end. And other recommendations are: do examine all the evidence in an objective manner. Do take into account the employee's explanation and their version of events. Do try to distinguish between fact and opinion and weigh it accordingly. And then do review the evidence on the balance of probabilities, i.e. what is more likely than not to have occurred. So finally, if you're dealing with an investigation that throws up no smoking gun, address the challenge. You might be faced with establishing the truth when it's one person's word against the other, and in that case you'll have to make a judgment as to what seems most likely, and your job is to make a recommendation about the next stage, such as should there be a disciplinary hearing.
I hope that's been very useful canter through conducting an investigation.
Yeah, and as ever, if you've got questions about handling an investigation or a disciplinary process, do get in touch. And that's it for this time. Thank you very much.